My name is Brad Bernstein. I'm an immigration attorney. We're helping people, we're informing people, we're making people's lives better, and we're changing people's lives in a positive way. Update on Biden's new immigration laws. Anyone who's been in the United States for more than 10 years, if they entered without inspection and are married to a U.S. citizen, will be granted a parole in place, which is a document that will allow them to file an adjustment of status application to get their green card, their work permit, and advance parole travel permission. In addition, CBS News is reporting that Biden will announce waivers for people who are living unlawfully in the United States to obtain H-1B visas, O visas, E visas, and other employment-based non-immigrant work visas. More updates as I know them. President Biden announced that if you graduated from a United States university, even if out of status, but have a job sponsor, you will be able to get a waiver to go home and return with a work visa or perhaps even a green card through perm labor application. I will advise you what to do. You cannot enter the United States on a visitor's visa with the intention of getting married. That's the number one rule you have to know. That's a misrepresentation. Now, if you come to the United States to visit and more than 90 days lapses, meaning you're in the United States more than 90 days, and then you change your mind, and you say, I'm in love with this woman, I want to get my green card now, then yes, you can get married. The law presumes you changed your mind. If the marriage happens more than 90 days after your entry into the United States, then you go buy a license, you go get married, you file an adjustment application, you get your work permit in about 6 months, travel documentation in about 6 months, and in approximately 1 year, or a little more than 1 year, you get an interview for a green card where you have to prove you have a bona fide marriage with your spouse. That is, you live together and have a financial relationship together. I can assure you that if you're about to give birth in America and you show up at the airport and you say, my purpose is to see my friends, not to give birth, but you're about to pop, they're not going to let you in. If you get deported from the United States or you lived in the United States unlawfully and left, obviously, there are a lot of obstacles to return. You want to return to the communities that you left behind and be with your family, but you first have to reapply to the Department of Homeland Security to return to the United States, and here are the rules. If you were unlawfully present in the United States for less than 6 months, you don't have a bar to return, although your visa is no longer valid, and you would have to apply for a new visa, which is hard to get. If you were unlawfully present in the United States for more than 6 months and less than a year, you have a 3-year bar to return. If you were unlawfully present in the United States for more than 1 year, you have a 10-year bar to return. If you were found inadmissible at the airport, you have a 5-year bar to return, plus an additional bar based on why you were found inadmissible. If you were ordered deported and removed by an immigration judge based on a crime involving moral turpitude, you have a permanent bar, but there is a waiver after 10 years. If you were ordered or removed twice, meaning you got deported, came back, got deported a second time, 20-year bar, no waiver. And if you got deported for an aggravated felony, that's a permanent bar for life. Yes, U.S. businesses sponsor foreign nationals for green cards every day. It's a 3-step process. First, the employer has to file a labor application with the Department of Labor to prove that you're not taking a job away from an American worker by testing the labor market. You will have to be able to show that you have minimum requirements to fill the position. You have the skills and you have the experience and the education to do the job that you're getting sponsored in. Following the approval of your labor application, the employer files an I-140 visa petition for you, establishes that they intend to hire you when you get your green card in this position, and they have the ability to pay your offered wage. You would get put on a visa waiting list at that point, depending on what skill category you fall under and what country you were born in. There are different categories for unskilled laborers, skilled laborers, professionals, people with advanced degrees, and people with extraordinary ability, and then you either adjust your status or go to the U.S. Embassy for your green card. If your mom comes here on a tourist visa and you're a U.S. citizen, let her wait 90 days on her tourist visa and do nothing. After 90 days, put in her adjustment of status for her green card. If done properly, your mom should be able to get her work permit and travel permission in 4 to 6 months and her green card in less than a year. Good luck.